We have this sale-leaseback agreement between parties that later results in assignment, and this particular sale-leaseback, which is now effectively between Market Street and GE, has a repurchase provision. And the repurchase provision effectively says that if GE does not provide financing to improve the property, then Market Street, was JCPenney, now Market Street has the ability to buy back the property at a fixed amount, at the amount of the original price plus 6% a year, which, as Jonathan pointed out, can be totally out of whack with the real value, and in fact was out of the real value. It was maybe 3 times less, 1/3 the cost that it would have been. All right, so obviously the buyback provision is what happens here. So kind of what happens next? So Market Street tries to get financing from GE, right? And how do they do it? Well, they send a couple letters to GE asking for financing, but they don't mention paragraph 34, right? 2 different letters. From what I read in it, correct me if I'm wrong here, the first letter didn't mention anything about the buyback at all. The second letter made some sort of vague allusion to it, but didn't really draw attention to it, right? So now we get to the issue of bad faith. Now this is a contract, and the parties can live by these terms, but did Market Street have a duty of good faith to tell GE about the buyback provision? Did it have an obligation, implied in law, because of the duty of good faith, did it have an implied obligation in its correspondence to remind General Electric about whether or not there's a buyback provision? So what does the court have to say about that? So the district court grants summary judgment. So now we're moving from property to civil procedure briefly. Look, it all comes together. It's law school. A bunch of these subjects that all interrelate. What is summary judgment? Summary judgment is a disposition where there's no material facts in dispute, right? So by saying there's no summary judgment and finding for the pension trust, it is not just saying that Market Street acted in bad faith, but it acted in bad faith effectively beyond a material doubt, right? It's a even higher standard to grant summary judgment. And it's basically saying it is sure, without a trial, that Market Street acted in bad faith. That's what the trial court is saying, because it granted summary judgment. And so it answered this issue not just yes, but yes, a resounding yes, because it not just had a trial that came in GE's favor, but it actually granted summary judgment in GE's favor, answering this question very, very strongly that this was bad faith. Judge Posner has a bit of a different view, right? So how does Judge Posner respond to the district court's strong yes in response to this question? So all he determines at this stage is that summary judgment is not appropriate. So does he answer this issue? No. Posner does not say Market Street acted in bad faith. He also doesn't say Market Street acted with good faith. He instead asks a new question. He asks whether Market Street tried to trick its partner. That's bad faith. And the problem with the trial court is they didn't ask that question. They assumed it. And given the facts and circumstances of this case, the trial court didn't do enough analysis, right? This is a fact and circumstances analysis, and quite frankly, hard to resolve at summary judgment. Summary judgment means there is no dispute as to material facts. Posner is simply saying, yes, there is. We did not ask Market Street through, what was his name, Orenstein? Orenstein. We didn't ask Orenstein whether or not he was trying to trick these guys. We didn't ask him that. We don't know that. We don't know what was Orenstein's state of mind. Why do we care about Orenstein's state of mind? Well, this is effectively an equitable doctrine. GE didn't have perfectly clean hands. They're not the white knight in this story. When are we going to give them the benefit of a bargain they didn't strike? When are we going to imply a term in their favor when they didn't necessarily have clean hands? Only if we feel certain or at least that a jury feels certain, maybe better than the judge, as a matter of fact, that Market Street was trying to trick its counterparty. Now that you can't do. An accidental omission? Fine. A duty of candor? Not required. But tricking the party you're in a contract with to try to get the benefit of a bargain that you never really struck, that wasn't the commercial purpose of the deal, that, for Posner, would be bad faith. We just don't have enough facts on the table to decide whether that happened here. He does say a few other things which I think are insightful. He says that a duty of good faith is something less than a duty of candor. It's not necessarily true that Market Street had to say something about paragraph 34. The trial court seems to feel that because Market Street did not mention paragraph 34, they were not acting with good faith, right? Posner obviously disagrees with that and says, no, simply omitting detail about paragraph 34 is not enough. There is no duty of candor. You don't have to show all of your cards just because you're in a contractual relationship. Maybe one way to think about it is just because you sign a contract with someone does not make you the brother's keeper, right? To use an allegory, right? Does not make you responsible for them to do the right thing. I mean, yes, now you're in a relationship with a contract counterparty, but especially where you're dealing with like corporate contracts between effectively massive multinational conglomerates, that duty is somewhat limited. The law frequently contemplates that people can take advantage of someone else's ignorance. I mean, it would be very hard to, otherwise, like every time you had more information, you would have to disclose it. I mean, that can't be exactly right. Something less than that must be required. He says, even after you sign a contract, you're not obligated to become an altruist. You don't have to divulge everything. The duty of good faith is something less than that. And the trial court got that wrong. They made that duty too big. Where do we draw the line on the other hand? Well, you can't take deliberate advantage of an oversight by a counterparty. And he gets into some law and economics about it, which is interesting to me and probably not to you, about just sort of the social utility of commercial agreements. And I think that is interesting kind of background to it. And, you know, that does inform a lot of his reasoning and thinking. Effectively, though, he's saying that there is social utility to parties taking on risk. And like we talked about, this contract was a risk assignment. GE now has the risk that the property value will go down and gets the benefits of the property value goes up. JCPenney and now Market Street has a big wad of cash and some liabilities. So maybe if the stock market goes up and the housing market goes down, good thing they had this cash to invest, or maybe they could invest in some other project, right? That was the risk-reward allocation that they agreed to. And one of the risks that the parties seemed to want to avoid is, I think JCPenney and then Market Street was concerned that it would dump a ton of money into improving this property and walk away with nothing. And it didn't want GE to take advantage of it. This provision, this buyback provision, was a way to prevent GE from taking advantage of JCPenney's investment in its stores. It wasn't intended to give JCPenney the property at a third of its value. Whether or not they're allowed to do that, however, right, really depends on what was their motivation. Good faith is somewhere in between. It's something more than tort liability. It's something less than fiduciary responsibility. And, you know, he brings up as well that it is not a duty of candor. It does not mean you have to show all of your cards. And just because you're in a contractual relationship, you don't have to show all of your cards there either. But there is some duty that emerges from being in a relationship, and I think we can summarize it by saying that when you are in a contractual relationship, you cannot take deliberate advantage of an oversight by your contract partner.